Do we have like flavors of pizza?
I ordered from Trios, tomato pie.
Good evening. I'd like to call to order. First on our agenda is a continuation of the public hearing and to take action on the Beaderwood Residential Partners LP application. And before we start, may I have a roll call, please? Here. Here.
Here. Here.
Here. Here.
Here.
Here.
Here.
Here. Here.
Here. Be advised, Commissioner Jimmy DiPlacido called. He will be running late. So if that is, Commissioner Zappone is excused. And so at this time, would everyone please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Correction, Commissioner Zappone is in attendance. Let the record reflect that. Thank you. At this time, I'd like to call on Mr. Michael Clark, the Township Solicitor, for opening comments.
Thank you, President Luker. As you indicated, we are here for a continued hearing for the conditional use application of Beaderwood Residential Partners LP with a tax parcel number of 30-00-66644-007. This continued hearing has been properly advertised. The board first heard this matter on November 19th of 2018. The board heard the presentation from the applicant. The board took public comment from interested members of the public, and then we adjourned the hearing until a later date. The applicant is here this evening, represented by Mark Kaplan. There is a slight change, or I should make slight, I shouldn't editorialize. There is a change to the application, which Mr. Kaplan will review for the board this evening. So, Mr. Kaplan, whenever you're ready.
If you recall, at the hearing, we described the modifications that we proposed to the 4 entrances along the strip in front of the Beaderwood Shopping Center. And if you recall, starting on the west, we propose a traffic light and all types of improvements inside so that the traffic is channelized. If I go all the way to the east side, which is to the east side of a Whole Foods, we propose no change to that driveway, but we propose that the median in the middle of the road be closed off, which will effectively make that access way right in and right out. And we come to the next entrance on the west side of the Whole Foods. Again, we propose a light and channelization there. Where the 2 traffic signals would be also pedestrian crosswalks. That leaves us one more entrance, and that's the entrance that if you come in now and you go straight in, you go all the way to the back, Panera is just about in front of you, a little bit on the left. Our proposal was to make that also right in, right out only. We proposed that we make some changes when you get to the parking lot so that we can channelize that traffic. We would take the parking that now goes back that we call single loaded, so there's just 1/2 of a double parking, and we would add 13 parking spaces there. As I said at our hearing, We have the approval of the owner of the shopping center of all of those improvements, except for the changes to that last driveway that I talked about. We do not have their approval yet. They've expressed some concern about it. We have to take that off the table because we don't control that. However, traffic engineers believe that, and I think logic dictates, that when we eventually get the traffic signal in on the west and on the east of that, quote, main driveway now, the bulk of the traffic will be using those two signalized intersections. So we have not been shut out totally by the owner of the shopping center. And in fact, Fred told me today that he's meeting with the Cornerstone people in the next 2 weeks, and we hope to work through this. We intend to continue to try and work through it, assuming that you approve us tonight during the land development process. And that's really the change. I think I spelled that out, maybe not in as great detail at the end of the hearing. So other than that, everything else that we have said is consistent, and we would, what we have suggested is that you approve the conditional use with the condition that we make all of the improvements on the supplemental plan except for the one that I just described. And Mike and I talked today. All of the, just so you know, all of the handicap ramps, all of the bike racks, all of the landscaping, everything else is as we said that it would be in our presentation.
Thank you. Are there any questions from commissioners? Commissioner Gillespie.
Sure, thank you. Mr. Kaplan, I just wanted to check, when you had your presentation, the last entrance exit is a right in, right?
Which way? The east side?
The last one, I know, all the way towards York Road.
The west one.
Okay.
Yes.
So how is that going to be? Is it going to stay the same? Because I thought that was going to lead to the back and up to the apartments.
Yeah, well,
Mark, can you use the microphone,
yeah,
please?
I'm sorry, I just couldn't see. On the plan, on the additional plan, we make significant internal changes so that we've got safe access through there. Basically, we've lengthened the throat, we've cut off, you've got to come in a substantial distance into the parking lot before there can be cross-traffic. And that's so that you don't get a jam up right by the entrance and have either a backup that sends traffic out blocking the road, or you have an accident. That's pretty well defined.
I just want to be clear, I'm just looking at the drawing here. Right now, it's right in, right out. I happen to work in that.
Okay.
that building. And so we always come in the back way, all right, which will change, I know, with the driveway that's going up the back. So now it's going to be both
It's going to be a
ways.
full
Full
access.
That's what I thought, okay.
Yeah,
Just wanted to-
and a traffic light
And the light there.
and
Okay.
pedestrian crossing.
Okay, all right, thank you.
So you're going to have pedestrian crossing there,
Okay,
and if that's the first access, then the first and the third, and we'll get rid of the ones that are now sort of at random, and we all think it'll be much safer.
well, I think so, as today a woman came flying across there, and I came out the back, and it's the Wild West in that parking lot. Thank you.
Oh, yeah.
Thank you.
You're welcome.
Any other questions by commissioners? Commissioner Klein and then Commissioner Myers.
So, Mr. Kaplan, so how are you proposing we handle this as far as a condition? Because we do have a interest in seeing continued conversations with Cornerstone and trying to get this try to get this squared away with them if it's possible. Is there any help that the township could, in those conversations, be involved that you think would be helpful, or Fred would think would be helpful?
Well, Commissioner Klein, let's let Fred meet with the Cornerstone people. Let's see if we can convince them that what we're talking about makes the most sense. We've got, I don't want to say absentee management, but they're not here all the time like the rest of us are. So we want to attempt to convince them. And then if we can't convince them, Steve, I'd love your help.
Well, I'm not talking about my specific help, I'm talking about the township in general.
Yeah, of course.
Right.
Of course.
Okay.
We would love the help. I mean, once we got into making the changes, it all makes a lot of sense. The parking lot will work a lot better, and you won't have what Commissioner Gillespie said, that we all know what happens. It's free run across.
Sure.
It's free run across the parking lot.
And so is there something, and you don't have to answer this right now, but before we actually take any action on this, but can you propose any kind of language that we could put in as a condition that would immortalize the idea that you're still working on it and that the township is willing to be involved in those conversations, anything along those lines?
Hey, let's do a separate letter. Let's not get involved with a condition and then somebody misinterpret what that condition is, because we have no power. We're begging. So we're going to be back here during land development, and we'll report to you on what we're going to do. Steve, I hate to put conditions of approval that say something like the applicant and the township are going to cooperate and we're going to use our best efforts. That's a recipe for somebody who wasn't here at the time that we did it, getting us all in trouble. So I'd rather not, but if you want to put something that's non-binding on us, that expresses our intention, then let's do it. But we're saying it here in public, and we like the idea.
And so Solicitor Clark, what's your feeling on that aspect?
Well, it's difficult to enforce or impose a condition on an applicant when they are unable to meet that condition solely on their own. When there is a third party who at this point we have no jurisdiction over and who they have no control over, it's difficult for us to make a condition saying you must do this, because in essence what you're saying is you're giving this authority to this third party. There is still the land development phase. There is still the opportunity during land development to continue to review this issue with the applicant. And I would agree with Mr. Kaplan that we can put together a side letter that says we're going to agree to try to work together on this issue. But I think the more important issue is that they have to come back here for land development. They are going to be involved with us. They are going to be meeting with the township. They are going to be meeting with the township professionals to review this. So we'll continue to be part of these discussions with them and with the owner of the property.
Okay. Then I wanted to move on to there's a line item here. It says creation of a potential future connection point from the site to Noble Town Center. Is that, I think we talked about this before, that there was a back access point. Is that what you're talking about in there?
So the way the plan goes, you know, the parking lot goes uphill.
Yep.
So when you get about 2/3 of the way, we're level, our second level, I believe it's our second level, is, we did this purposely, is on the same level as the parking lot up there. And we would all like to be able to get an easement from the owner of the adjoining center only for emergency access, nothing else.
Right.
We have tried, Larry had tried, the shopping center's still owned by who? DDR or some national company? We had discussions with them. At one time, they came to us and we went to them, and they were talking about doing additional development, and that never came to fruition. So the bottom line is, we would love to get that connection. But again, we don't have power, we don't have the power to force them to do it. Now you do. You have the power to force them, and if you elected to do so, that would be great.
And with what cooperation from Beaderwood, from Brandolini or the partnership?
Well, look, I'm not sure that this is the time, but
Okay.
if the conditions said that we use our best efforts to get them to do it, and if they won't agree to it, that the township would condemn that access easement, we would agree to pay all of the costs. So, and what I have seen is that if we had that in an agreement, or if we had that in a condition, it gives Fred the ability to go to him and say,
Right.
look, this is going to happen. Why don't you just cooperate? You own the property. You're going to want to do other things in the property. We and the township are asking you for something that's got very little chance of ever being used, and you'll be a good guy. So that's the only way I know to do it. And this one, I think, is important enough that we would really like your help in that regard.
And that's something, I know that's not necessarily a condition in this stage of the game, but that's more of a land development item, is that my understanding?
It could be a land development item. It could also be a condition that you could make as part of this conditional use approval, that if the township in attempting to acquire this access road expends any tax dollars with respect to the acquisition of an easement, appraisals, surveys, legal fees, that the applicant would be responsible for reimbursing the township. You could make that a condition.
Okay.
We'll put the money up front if you decide to go ahead and do it. Done this before. The way I have done it, Mike, is that we have X number of days to go ahead and attempt to get it, 90 days, 120 days, whatever happens. We would report to you on what our efforts were. And if we can't get there, you would condemn the easement, and we'd pay all of the costs.
Okay.
So something for you to consider.
Okay. So we should write that down just in case that's okay, thank you. And then my last question is, you said about the accessibility items, which I know Commissioner Sanchez had brought up in previous meetings. I'm assuming you'd be agreeable to that becoming a condition in the conditional use?
I think, well, explain to me what you're talking about. I thought that it's all on our property, or what are you talking about?
Commissioner Sanchez is more familiar with it, so I'll let him address it.
Right. It's more the, I believe it's on the Cornerstone property that we were just talking about. No? Fred, you want to chime in on that? Not to call your witness, Mr. Kaplan, but
It's fine. Don't we show the, well, maybe,
this is like in front of Panera, we're talking, a
I
longstanding.
believe this issue is, I'm sorry, Frederick Snow, Brandolini Company's president. Frederick, F-R-E-D-E-R-I-C-K, and then Snow, S-N-O-W. This is an ADA issue in front of where Panera Bread is. There's an elevation difference from Panera Bread's sidewalk to the adjoining roadway. And they, I believe, had a resident that, a disability issue, had an issue with this. And we've commented in the past that we would work with Cornerstone and ourselves to rectify the ADA issue there because it's there whether or not it's part of this process or not, so.
And one more item on that, it was also the addition of multiple curb cuts, for lack of a better word, wheelchair.
Right, they would all have to be
accessible.
ADA accessible, just
Right.
per code and what we'd have to do now, correct?
Because the issue is, there might be I don't know exactly where the cuts are located, but there might be one in front of Panera, but then, there's not another one for 150 feet or so, and so.
Let me talk about the real world. I represent a number of shopping center owners, and there are people out there, you know what I'm talking about, Steve. There are people out there, there are organizations, it's almost mind-boggling, funded by the government, that go around and come to shopping centers and apartment buildings and start lawsuits over failure to comply with ADA requirements. And they're usually 60% correct because some of this is sort of gray because of older centers.
Right.
I don't speak for Cornerstone, but if Brandolini goes to Cornerstone and says, we're going to fix 3, 4, 5, or whatever of these, they ought to be very happy.
Yeah,
just wanna make-
I mean, we wanted to not have to go to that organization, so to speak, to,
Right.
do it
Yeah.
It was our
the
full,
easy way.
yeah,
so
it's
to
our full
speak.
intention. I think it even shows on the conditional use plan that that's what we were going to do. So just to be absolutely clear, that we're not talking about any interior space. We're not going into Whole Foods and seeing if their bathrooms are ADA. This is just the
Correct.
work that we're doing. Exactly. Okay.
Is that, where's Chris? Chris, do we show any of this on our plans?
Before, excuse me, Mr. Kaplan, before Chris answers, could you have him come to the microphone
Oh, sure.
with his name and address?
Chris Denoulis, he's our engineer.
Christos Danoulis, Bowler Engineering.
You're going to have to spell that.
Christos, Danoulis, Dinoulis. So part of the conditional use plans did show, obviously, improvements in the parking area with crosswalks from those ADA spaces to the sidewalks along the frontage of the retail space. So the intent is to make those upgrades to the ADA ramps where necessary.
Are the ADA ramps shown?
I don't believe all the ADA ramps are shown on the current plans.
All the crosswalks that come from the ADA spaces to those sidewalks in front of the shopping center, are those shown with ADA ramps? Just to clear my question up.
So I don't know if the actual ramps are shown because we don't have all the grading done, but the intent is that a ramp would be put at all those locations.
So would it be acceptable just to, since you've made conditions about the accessible parking spaces to be in compliance and the walkways, and I'm also asking this question to Commissioner Sanchez, that we add a condition in the conditional use approval that you will also follow through with the ADA ramps to get up onto the sidewalks?
No problem.
Yes.
Okay. Is that,
I think we're covered on that between our easement agreement and the approvals.
I agree.
Is that-
And
is that what you're-
that satisfies my
Okay.
concern, yep, absolutely.
Okay.
thank you.
Commissioner Myers, then Commissioner Spiegelman, and then Commissioner Zepone.
Thank you. I'm a little confused. You may have to backtrack a little bit to help me. The issue that I'm concerned about, and I don't know if this is the road, the Connect Road that you're talking about, but I would like you to speak to the road that will allow fire trucks to enter without any problem.
Okay. So the fire trucks will be able to enter now, the plan that we have. And we've shown that to the fire chief. All of the road that comes in and goes circular and goes around the left side or the west side, and the road that goes in under the parking garage are all, those turns are all accessible by the fire trucks. And the trucks can get all the way around in the back. They may have to back out ultimately, but they can get in there. The issue that we have all been concerned about was we wanted someplace, a second access from the property, into or from the property. The only place that is possible, because we don't own the property behind us, the grades change. But as you go up the hill, so to speak, in the adjoining shopping center, you with me? In the parking lot, and you're all the way over on the right side of that parking lot, right by us. When you get about 3/4, 2/3 of the way up, we are now at the second level of our parking. So we can have a second access point from the second level just by putting a little bridge there. And that's what we're talking about, and that's what we're proposing, but we need the permission of the adjoining shopping center.
And that's what you're discussing, the possibility of condemning?
Yes,
Okay.
that's your choice. That would be condemning about the most inconsequential easement, inconsequential from the adjoining property owner's point of view, because the only time that gets used, it would not be an entrance or an exit that would be used regularly. It would only be an emergency access in the event of a problem.
Well, but that's the most important thing.
Well, we're agreeing.
Okay.
We're totally in agreement.
I'm a little, and this might be a question for our solicitor. I'm a little confused that we're proceeding with this and we're not really any further along on this access road, on this emergency access road. Why are we proceeding with this without knowing that answer?
The
And I
emergency.
certainly would hope that condemnation would not be an issue.
Well, I would hope that it wouldn't have to come to that also. I think everyone's familiar with the property, and the part that's going to be adjacent that I think they're seeking an easement across is a parking lot. So it's not that as if we're taking someone's residential property or we're taking part of their buildings or anything along those lines. But I would hope that it wouldn't come to that also. But the issue of the access is another issue that will be more properly for the land development process and will be explored more fully with the applicant during the land development process. They have preliminary, my understanding is there have been some preliminary discussions with the fire marshal's office, and the main entrance, there is no issue with respect to any of the fire apparatus being able to make it to the building, and then there's no issue with respect to it being able to stage around the building. But again, that's something that will be more fully discussed once they submit their land development plans. So I'm not saying it's not something to be concerned about at this moment, but the real time that issue is addressed is when we're going through land development.
But is it really fair, even to the applicant, to go that far if this issue exists now?
I think the applicant comes to us understanding that this is hurdle number 2. They had to get through zoning, they have to get through the conditional use process, and then they still have to get through hurdle number 3, which is through the land development process. I think that the applicant, and especially with an experienced attorney like Mr. Kaplan, understand that this doesn't mean they're home free after tonight, and they've made the decision to move forward with these plans, even knowing that they have other hurdles that they have to clear.
Mike, I just want to be clear on one thing. The plan has been reviewed from a zoning point of view. We're in compliance with everything. This property got cut up the way it got cut up a long time ago, and there is no other access. If you agree, if the board agrees to the condemnation provision that I'm talking about, and it's in an agreement, and we can go to the owner and just say, look, this is what we need, this is what the township wants, and if you don't do it, they're going to condemn it. My experience, they do it. When I just go and talk and beg without the the backing of the township, I don't get it. I mean, Larry called any number of times 2 years ago. Fred's met with him. So it can be solved if you agree, as I've suggested, that we try and get it. We use best efforts, and if we can't get it, you condemn that easement, and we pay all of the costs. And then the problem is solved. It's the only way I know to solve it.
It would seem, I don't want to appear argumentative, but it would seem to me that you've had plenty of time to work this out with the owner, and it seems that we're headed down the direction of condemnation. I can't speak for everybody on this board, but I certainly know of a bad experience this township had with that, and I don't know that I could ever support condemnation of private property for another private property.
That's your choice.
It appears to me you are taking us in that direction.
No, I'm not. No, wait a minute. I'm not taking you in that direction. This is a property that is zoned for the particular use. We have demonstrated access for fire equipment. We have demonstrated how when that fire equipment gets in, it gets access to the entire building, and it can be served. There's no question about that, and we've satisfied the ordinance. People generally would like to see a second access. Well, we can't get it, and I'm a little confused how you could say that we've had plenty of time to do it when, I mean, people in the township have known exactly what we've done. Larry tried to get the owner to do it. Fred went any number of times. So we can't force a property owner to give us this easement. You can. So if it becomes an issue of necessity, then the only way I know to solve it is for you to exercise the power of eminent domain. And that's what I was trying to say. What are you really taking? I agree with the solicitor. You're not taking somebody's house. You're not taking a piece of their property. You're taking an easement that would only be used in an emergency. So that's where we are.
And Commissioner Myers, just so we're clear, and I understand your concern, even if the board approves this conditional use application tonight, nothing we are doing, nothing we are putting in any of the additional conditions requires us to condemn anyone's property. Nothing we are doing tonight automatically says that at some point we are obligated to condemn someone's property. As I indicated, I would hope and I would think that it would not come to that, but the board in no way, shape, or form is obligated to do that. That is strictly within the authority of the Board of Commissioners as to whether or not they would take that sort of action. And the applicant understands, as we've discussed here this evening, that again they're kind of operating at their own risk by getting this when there are still other hurdles that they have to cross. Clearly, it would be easier for them if we just went out and condemned the property, but we're not required to do that, and nothing we are doing this evening, if you approve it, commits us to have to do that.
Thank you.
Okay, Commissioner Spiegelman.
Thank you, Mr. President. With apologies for going backwards in one topic, I just wanted to clarify a comment that you made, Mr. Kaplan. It wasn't just one resident who reached out to Commissioner Sanchez regarding the ADA ramp issue. It was quite a number of residents that reached out to Commissioner Sanchez, myself, and some other commissioners, and that's actually what got the whole conversation started. So I just want to voice my support.
Not a problem.
No. I just want to voice my support for that condition as described by Commissioners Klein and Sanchez. Thank you.
And thank you for clarifying that, Commissioner Spiegelman. I meant to say it wasn't just a sole resident.
Commissioner Zappone, thank you.
Yeah, Commissioner Meyer just brought up my concern regarding the...
Speak in the microphone, please.
about the emergency equipment getting behind that building. And at this point, it doesn't seem like it was resolved. So I'm very, very uncomfortable with that. So I just wanted to express
What are you
that.
uncomfortable with?
Fire trucks, ambulance, and what have you getting behind there.
Getting
Okay.
behind, well,
We just discussed here, okay, about the emergency equipment, okay? We just discussed that.
I'm sorry. I think there are two different issues, and I just want to make sure that we're talking about them.
It's the same issue.
Okay, any other comments from commissioners? Commissioner Vice President Klein.
I just want to clear up something. So is this access point that we're talking about, is that a requirement of the subdivision and land development
No.
ordinance, or is that a desire of the fire marshal's office?
The latter.
The latter.
But I want to make sure, because I don't think that it's clear, the access presently designed for the fire department works. It works. It gives access all the way around the building, all the way around three sides of the building. All of the truck turns work. The fire department will have access to the property. That's one issue. The other issue is that in any development, no matter what it is, you would always like to have a second access, not so much for fire, but in case of some emergency where a road gets blocked up. And that's what we're talking about. We are not talking about the ability of the fire trucks to get in and take care of any problem. We're talking about an emergency access.
Right, so my understanding is, and I know we haven't had subdivision and land development review letters, we haven't had a formal letter from the fire marshal's office or from the engineering department about the SALDO requirements, but what you're telling me is your understanding is you meet the requirements of the SALDO relating to fire access. The second access that we're talking about coming from the neighboring property is a desire, not necessarily a requirement. In your understanding, is that correct?
That's accurate, yes.
Okay, thank you.
Okay, thank you. Any other comments from commissioners?
Mr. President.
Commissioner Sanchez.
A question for Solicitor Clark, and I apologize, I meant to, or I should have discussed this with you earlier. Do we need a condition that this will resolve the underlying zoning litigation in the matter, or will that be done separately? I mean, I realize it's an understanding of the parties, but.
Ben, agreed. We agree.
Yeah, I don't think we need to make that a condition of this approval, but I think that's the ultimate intent, that this will resolve all of the litigation, because essentially you're approving the conditional use application, which in essence has rendered both of the zoning hearing board appeals moot.
Thank you.
Okay, again, any other questions from commissioners? If not, before we move forward on this, is the applicant complete in their presentation?
I am.
Thank you, sir. At this time, I'll take comments from the public. Please adhere to our 3-minute speaking rule and
Laura Lehman,
Microphone.
1431 Bryant Lane. L-O-R-A? L-O-R-A, Lehmann, 1431 Bryant Lane in Meadowbrook. Okay. So I was part of all that happened from the beginning on that property that led to this. It got to the point of so many lawsuits filed by this particular applicant against the township. It was unbelievable. And now, as was just said, they are back here without the condition that they need, with the only way to be the taking of somebody else's property, or for them to go back and redesign their particular thing. This is something that should not be done, and they have bullied and threatened their way all the way to this point. I think anybody who was around long enough to know the junior high school was full when this started, and it just went on and on and on, and ended up, after they got everything they want, 244 units on a steep slope where only 8 houses would have been, and now they still are wrangling over little details like this. They shouldn't have come to this hearing unless they had that solved. If they didn't have it solved, you don't have to take anybody's land. They can redesign what they have and make access themselves. That's not okay. It's not okay what they're doing.
Thank you. Any other comments from residents? Comments from residents? If there are none, let me get clarification from council. If we approve this conditional use hearing application tonight, that moves this application forward in the process to land development. Is that correct?
That is correct.
Okay. So I'll need a motion to do so. Correct?
That is correct. And the motion would be to either approve the conditional use application with the additional conditions that were discussed this evening, or to deny the conditional use application.
So can I just mention one thing before we do that?
Go ahead.
So, yeah, I just want to make sure we're all clear, because I think there is some confusion about this fire access issue. There's nothing for us to be solving right now, because as I understand it, if indeed what the applicant is telling us, that they've met the requirements of the subdivision and land development ordinance with the way their plan is, right now, without the fire access coming off of the adjacent property, that we're not solving anything. The only thing we're doing is, if we want to be part of or help out with the additional fire access that's not required, then that's up to the township, but that's not a requirement. That's something that's being desired. We haven't heard specifically from the fire marshal's office, but that's something that's being desired by the fire marshal's office, assuming that that translation is correct. Is that my understanding here? Because,
well,
I don't want to.
I think there are two issues, Commissioner Klein. The first is that the issue of the fire access is not properly before you this evening regarding a conditional use hearing. That's the first issue.
Right.
The second issue is the applicant's position regarding whether or not a second access is needed, or if their driveway as currently configured meets township standards and they don't need a second access. It cannot be commented on by myself or township staff at this point in time, because we don't have a land development application. We don't have review letters from engineers, from our traffic consultants. So all of that will be determined as we move through the land development process. If the applicant is correct that under our ordinance that they only need the one access, they don't need a second access, then that second access would be something that the applicant would want, and sort of belt and suspenders, or that the township would want, but it wouldn't be required. If the applicant is wrong, then that could result in the land development application not being approved. But it's until everything is submitted, till all the engineered drawings are submitted and reviewed, we cannot definitively say.
So let me clear something up, because I think it makes a difference as to what condition, if any, is put in to this potential motion for relating to the fire access. So if indeed, as we said, and I know how attorneys love hypotheticals, if indeed they're correct that they don't need the second access and the township was to get involved, it would only get involved if it deems something, if it deems necessary, or that that the township or the board wants to work with and get that second access because it's desired by the fire marshal's office. If this fire access is an actual requirement of the subdivision and land development ordinance, then that would be something that they would have to comply with or get a waiver for. Is that my understanding?
If it's required, the second access is required, they would either need a waiver or they would need to comply.
So my question or my comment would be that if we are going to produce a condition that's going to deal with this fire access, like we've talked about with Mr. Kaplan, that it reads in a way that if this fire access is a an additional requirement on top of the subdivision and land development and not a requirement of the subdivision and land development. Does that make sense? I don't want to, to what Commissioner Myers says, I don't want to necessarily give them the help if it's something that's already required by the subdivision and land development, or if it's something that the board and the township wants because we think it would be safer, and that's what the fire marshal's office is recommending, and we want to help out in that situation, that's a different story.
I think the only condition that Mr. Kaplan has agreed to this evening is that if we expend any funds in the acquisition of the secondary access, whether it's required or whether it's not required, if we expend any funds, the applicant will reimburse the township. That's the only condition that we're putting in. We're not making a condition that we're going to condemn. We're not making a condition that we're going to grant them a waiver. We're not going to grant anything. The only condition is if we have to spend money in exploring it, appraising it, doing a survey on it, anything on it, they're going to reimburse the township.
Okay, and so, okay.
Then and that's the way it'll be, if you approve it, that's the way it'll be written in the,
So if it is a requirement of the subdivision and land development ordinance, we could just fall back and say, well, you have to do it anyhow. So
Correct.
Why would we get involved in it?
Correct. And I don't think they're, correct, right.
I know Mr. Kaplan doesn't believe that's the case, and I understand that. We haven't gotten that far, but I just want to make sure we clear up the differences between the two situations.
Right. But I also think what's important is Mr. Kaplan doesn't believe it's the case. And if he's correct, but we decide to go through it with it anyway, and we decide to negotiate with the adjoining property anyway, and we have to spend money in negotiating with that adjoining property owner, even if it's not required, the applicant's going to pay for it.
Understood.
Right.
So with that, I mean, I'll make a motion to approve the conditional use application with the, I think it was the additional conditions related to what we were just talking about, the financial burden for the emergency access, and the agreement that accessibility ramps will be installed in coordination with the accessible parking spaces and crosswalks within the parking area of the existing shopping center. Is that correct? Yep. So, and I think that was it. The other item that we talked about, which was going to be dealt with another way. So, with that, so that's my motion.
I second the motion.
The motion's,
Could be Commissioner Bowman, me.
Commissioner Bowman?
Commissioner Bowman.
Okay. So the motion's been made and it's been seconded. May I have a roll call vote, please?
Commissioner Myers?
No.
Commissioner Brodsky?
Yes.
Commissioner Hoffman?
Yes.
Commissioner Sanchez?
Yes.
Commissioner Thompson?
Yes.
Commissioner Schreiber? Yes. Commissioner Carswell?
Yes.
Commissioner Spielman?
Yes.
Commissioner Mayhew?
Yes.
Commissioner Glassby?
Yes.
Commissioner Saccone?
No.
Commissioner Bowman?
Yes.
Commissioner Klein?
Yes.
Commissioner Luker?
Yes.
12 in favor.
Okay, the motion passes. With that, I'll entertain a motion to close the hearing.
So moved.
Okay? Hearing is closed. Thank you, and the motion is passed. Thank you. Tell me when Lori, let me know when I can go. Okay. Good evening. Welcome to the continued public hearing on and consideration for adoption, a zoning ordinance and map amendment for the applicant BET Investments Incorporated. At this time, may we have a roll call, please?
Commissioners Myers? Brodsky? Here. Rothman?
Here.
Lucido? Sanchez?
Here.
Thompson? Here. Schreiber? Here. Carswell?
Here.
Spielman? Here. Mayhew?
Here.
Glassby?
Here.
Saccone?
Here.
Bowman?
Here.
Klein?
Here.
Here. Would everyone please stand for the Pledge of Allegiance? pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. For the record, Commissioner Jimmy DiPlacido is excused. And with that, I would like to turn it over to our solicitor, Mr. Michael Clark, for comments.
Thank you, President Luker. This is a continued hearing for BET Investments. The hearing was commenced on December 18, 2018. At that time, the applicant presented its case. Those with party status were allowed to question the applicant, and then we began public comment. Because of the lateness of the hour, the hearing was continued, and it's been continued to this date, and it has been properly advertised. During the interim from the 18th until this evening, the applicant has made several modifications and amendments to the proposed ordinance. So the way we would proceed this evening would be that the applicant would go through the amendments. Those who had party status at the original hearing will be permitted to question the applicant's witnesses based on regarding the amendments, on what has been changed since the last time, and then we will allow the continuation of public comment, board, and then board comment and board questioning of the applicant.
Okay, thank you. Mr. Gunlock?
Yes, thank you, Mr. President. Rob Gunlock for the applicant. We agree with the summary of Solicitor Clark for the record. Just a few housekeeping items, if we may, Mr. President. First off, if we could just mark a few exhibits. Exhibit, I believe we're up to A9. Exhibit A9 being a letter that I sent off to Solicitor Clark dated January 28th, 2019, summarizing the notice requirements that were complied with for this hearing, along with the documentation that Mr. Clark's office has concerning the advertisement. We'd like to mark as Exhibit A10 a red-lined, or what I now understand to be a blue-line copy of the proposed ordinance amendment to amend the zoning ordinance to establish the new H12 use. As Attorney Clark summarized, Mr. President, we did receive, the night of the last hearing, some comments from the commission here. We received some comments from the public. We took good notes. We met with township staff. They had some additional comments. We incorporated that into this revised ordinance amendment that has been sent back into the township under cover letter of January 9th, which we understand has been provided to all of you. So that ordinance amendment, which is on the screen, we've marked as A10. We'd also like to mark as A11 a letter from the Montgomery County Planning Commission dated January 19th, 2019, that's been provided to the township with their recommendations in support of these two proposed ordinance amendments. And if I can remind you, there are two amendments. A lot of our discussion has been related to the ordinance amendment to establish the new use. There's also an ordinance amendment to rezone 4 parcels to the AO zoning district. So with that background, if I may call Mr. John Kennedy. Mr. Kennedy was sworn at the last hearing and remains under oath, and I'd like to call him for the limited purpose of giving the commission a summary of the revisions to the ordinance amendment since we were here last. Can I proceed in that matter?
Yes, sir. Thank you.
Mr. Kennedy, you're still under oath?
Did you want to put the microphone so Mr. Kennedy's voice can be heard? Thank you.
Mr. Kennedy, you were here at the last hearing and heard the commission's comments, correct?
Yes, I was.
You also heard comments from the public.
Yes, I did.
You participated in a township staff meeting where staff conveyed some additional comments.
Yes, I did.
You then worked with my office to incorporate those comments into the ordinance amendment that is before the commission this evening.
That is correct.
Okay. And we have a blue line or red line copy of that document on the screen. You have one in front of you. It's been provided to the township back on January 9th. Could you please run through and summarize the revisions to that ordinance amendment since the last hearing?
Sure. Again, all the changes that have been made are in blue. On the first page, there's just a clarification added regarding one of the requirements for H12 use. On the second page, which is the AO district dimensional standards, there were a number of changes which came out of the last hearing. The density is changed to 20 units per acre. The minimum lot width was adjusted to match the text. Elsewhere in the ordinance, the side yards were increased to 50 feet. Building coverage was decreased. The impervious coverage maximum was also decreased. Green area minimum was increased. And there was some clarifications made in the comment section of that table. On the third page, which gets into definition of H12, again, the density is adjusted to 20 units per acre with a cap of 26 units per acre, utilizing bonuses. A number of the bonuses were revised. Primarily, the bonuses were reduced in terms of their value of DU per acre, and there was primarily one bonus was eliminated, the de-emphasized parking, and one bonus was added, which was for green roof. And the other changes are primarily just clarifications and also reductions in the amount of value that they have.
In terms of the density, Mr. Kennedy, the net there, under the prior version, there was a maximum of up to 24 that has now been reduced down to 20, correct?
That is correct.
And the maximum with the bonuses was 36, and that has been reduced now down to 26.
That's correct.
Is the provision still remaining that the use of those bonuses are determined as part of a conditional use hearing?
Yes, they are. On page 5, there was a typo corrected under the minimum acreage. There was also a clause added at the bottom, which would be a declaration, which would be recorded against the property. Basically, that's so that the units would be deed restricted and there would not be any school-age children that would be allowed to live in the units. Finally, on the last page, one of the clause regarding reserve parking was removed, and also there was clarification of the description of the comprehensive use matrix table, and it's my understanding that the table itself was also added in this version of the ordinance. What the table shows is that this is a use that is allowed in the HO, in the AO district, and is only by conditional use and is not permitted in any other districts.
Mr. Kennedy, at the last hearing, you testified that, in your professional opinion, that these two proposed ordinance amendments were consistent with the Township Comprehensive Plan and the County Comprehensive Plan. Do you recall that testimony?
Yes, I do.
And based upon this revision to the proposed ordinance amendment to establish the H12, together with the proposed ordinance amendment to rezone 4 parcels to AO, is your opinion the same, that these two proposed ordinance amendments are consistent with the Township Comprehensive Plan and the County Comprehensive Plan?
Yes, it is.
That's all I have for Mr. Kennedy. Certainly he's available for any questions on those revisions.
Okay, thank you. Are there any questions of Mr. Kennedy? There are none? Thank you, sir.
Thank you. I did have one question.
Okay, hold on.
I did have one.
Hold on. Please, you're out of order, please. Hold on. Vice President Klein.
So I think we covered this before, and I just wanted to find out, with any of the changes, can you give the board some understanding as to your understanding of other currently zoned AO properties that would be subjected, or would have the ability to incorporate this use that's included in the text amendment.
As outlined in the ordinance, there are a number of requirements. This is an option only available within 200 feet of a hospital situated in Abington, which means it can only...
2,000 feet?
2,000, I'm sorry, 2,000 feet, which would mean only Abington Hospital and Holy Redeemer. There is property located in the vicinity of Holy Redeemer, which is zoned AO. However, it would not meet the other qualifying statements. And I believe that was also brought up at the Planning Commission meeting last week.
So is your understanding that, are there any other properties besides yours that would qualify, that you believe would qualify with the stipulations that are in text amendment?
I would say no in my examination of the zoning map.
Okay. Thank you.
Okay. Excuse me, you're out of order. Whoever that is speaking in the back, please. Thank you. Any other questions, Commissioner?
Not right now. Thank you.
Any other questions of Mr. Kennedy from the commissioners? All right, your next
Thank you.
witness, please.
That's all we have, Mr. President.
Thank you. Excuse me.
You're out of order.
Would you please sit down?
You
Would you
are out
please
of
sit
order.
down? Are there any other questions of the applicant by commissioners? Okay, if there are none. I'm looking at a sign-in sheet that's in front of me, and if I remember correctly, the solicitor...
Our first
wanna go
order of
with party
business,
status?
our first order of business, Commissioner, President Luker, should be that those individuals who were granted party status at the original hearing should now be permitted to ask questions of Mr. Kennedy based on the testimony Mr. Kennedy just gave in this continued hearing.
And that's regarding the amendment.
Regarding the amendment.
Okay. Now, the first name I have on the sign-in sheet is Rebecca.
No.
No?
This would be those.
Party status
Those
first?
who had
Okay.
party status at the prior hearing, when the hearing was commenced.
Okay, I'm sorry.
If anyone is present who had party status at the original hearing, wishes to ask Mr. Kennedy any questions regarding the amendment, they should come forward and they can ask Mr. Kennedy questions on the amendment.
Mr. Clark, one point I failed to mention, and I'd like to mention it to the commissioners. I don't have a copy of the Township Planning Commission's recommendation, but the applicant did appear back before the Township Planning Commission on this revised amendment, and the Township Planning Commission did vote by a 5-3 count to recommend approval of both of these proposed ordinance amendments as revised.
And that will be made part of the record.
Yes.
Thank you.
Yes.
Okay, sir?
Okay, Herb McMahon, Herb McMahon, MCMAHON, 1046 Huntington Road. I asked a direct question back on December 18th whether any other properties would have fallen into this category. And basically, Mr. Kennedy said at that time he didn't know. Then he asked, he basically said he didn't know the size of Sunrise. And he also said at that time that there was no exit onto Huntington Road. He said that there was only one on Susquehanna. And basically what I've done is I filed a right to know, and Sunrise's, yes.
Would be the time for you to ask questions of Mr. Kennedy?
I'm going to ask that question. So the right to know said that Sunrise is 5.5 acres, and also that the Susquehanna is considered a primary road, and that there are 2 entrances and exits that lead out to Huntington Road. So that property, in my opinion, certainly meets all the criteria. So my question is, do you want to change your answer? Or you still don't believe that Sunrise could be used for H12?
Before you answer, Mr. Kennedy, could you put the microphone so we could hear?
Sorry.
In my research, I came to the conclusion that it could not be used because it needs to meet all of the standards. Even if it could be used, somebody would have to purchase it and demolish the site. There are no vacant, readily available properties that could be utilized in the township.
They themselves can change the property's use. They don't have to sell it, they could just repurpose it.
They could. They would also have to demolish the buildings that are there now, and they would also have to meet all of the other standards. I haven't examined that site in terms of if it meets all of the other standards.
Yet what standards are lacking?
You'd have to see a plan to see if they in fact can make it work in terms of circulation and coverage and so forth and so on.
Yeah, I believe that it would fit that use. And I think this is critical because the Planning Commission, Abington's Planning Commission, and also the Montgomery County Planning Commission has heard testimony that it only involves 2 properties. And if this is true, that if Sunrise does qualify, then I think that those 2 boards have been misled, and I think the public has also been misled. And I think the reason why that is important is, number one, we have recommendations from the Abington Planning Commission, a 5-3 vote in favor of this project, and perhaps if they knew of other properties that it involved, they would not have that same recommendation. Same for the Montgomery County Planning Commission. And I think the other important part why this is important is the areas, the other properties that may be used, those residents have never been notified. They've been denied any kind of party access or party status to this process. They haven't been notified. They've been denied any kind of public comment with this because they don't even know they're involved. And I would go on to say that I think there's other properties, like Mr. Markman owns a property that is at London and Old York Road.
Could you just direct any questions?
Yes, I'm getting there.
Right. You're just about
London
to-
and
the
Old
time
York
is up.
Road. And I think that if he wanted to change the use of that property, it would probably also qualify. And if he had to expand it a little, maybe he could buy the PNC Bank that's no longer being used. So wouldn't that property also have the potential to be used?
I'm not familiar with the property that you're referring to, but I suppose if you want to start playing what-if scenarios, you could say that almost anything could be rezoned to
But your
AO.
testimony is that there's only 2 properties. Either you've looked at it and studied it, or you
I
haven't.
have looked at it, and in my opinion, this is the only property that would qualify.
Okay, so you have looked at those properties. You either have looked at them or you haven't. I don't understand. It's
I'm
either
a
yes
little
or
bit
no.
confused by your question.
Right.
No, I'm just saying, it's either yes or no.
He
He
gave
has
you-
looked at it or he hasn't looked at it.
Well, he gave you his answer, so.
Yeah, so
if
last
that's
time
it-
he said no. So, I think that they've either studied it, if they're giving testimony at these public hearings, and it's sworn testimony because he's under oath and he was under oath on December 18th, that his testimony be accurate. I think that this is a very important issue that's very important
Well, according to Mr. Kennedy, his testimony is accurate.
Okay, what was the testimony?
There, in the past, there was several questions asked about property in the vicinity of Holy Redeemer. I have looked at all that property. In my opinion, none of that would qualify. The property that you just mentioned right now, I have no idea what it is or where it is.
Okay, because last time you said no. You said that you didn't know the size of it. Then you said that it doesn't really have an entrance or exit on Huntington Road.
Mr. McMahon, I think you're talking, he's a,
Far field here.
yeah,
Right.
just so you understand, and I think, somebody correct me if I'm wrong, but I think he was just talking about, you had brought up BET's property at London.
Yeah,
I think that's what he was talking about.
I have no idea
was-
what that is or where it is.
Right, but I
Okay.
think that's what your answer was, and now you're asking about the Sunrise.
Okay,
property.
I
just
got
wanna make
confused
sure
because
we-
he said last time he didn't know about that property either. And then he corrected himself and said that there wasn't an exit on Huntington Road. And he also said that he wasn't quite sure of the size. I just want to be clear, how many properties this involves, because I think it's very important to the township to understand, and I don't want to be argumentative, but at the same time, I want to nail this down. I want to understand it, because in just a little bit, you all will be voting, and I want to make sure that we all know what's being voted on.
Okay,
Because I think
thank
it's
you.
very important.
Thank you. Commissioner Sanchez, are you going to comment?
I just wanted to say, we can't all be talking over each other, because if the court reporter's trying to take this down in the rapid-fire questions and answers and stuff, she can't keep up. So just out of courtesy to her, let's.
Okay.
Can I try to
Go
clear
ahead.
things up here?
Commissioner Klein, go ahead.
So let me, I'm going to try to clear things up because I think Mr. McMahon's question is valid and we should have some clarity, the board should have some clarity. So my understanding is my recollection of the township's zoning map is that there's only a few areas that are zoned AO currently in the township. And I believe there's only less of those are close in proximity to a hospital. And my understanding is that those are the properties that are close to Holy Redeemer, which would only be one property, which would be the Meadowbrook Apartments property. And you've already stated that that property would not meet the requirements, and I think that's mainly because of the two-street.
That's correct.
The two-street requirement. Then it comes, the next area would be, there's only, I think there's 3 areas along Old York Road that are close to Abington Hospital, that 2,000-foot requirement that would meet that would be within that distance. So there's a portion of it is on Horace. I think it's Horace, which is further down towards Highland. There's a portion of that that's AO, but it's all split up properties. So yes, I don't know if anybody could ever assemble 5 acres on one side of the street. So my recollection is there's not enough property there to assemble to get 5 acres on one side of the street that would qualify, nor do I think they could get 2 street accesses. But that's one area that's AO. The other area is the Sunrise property, which
Correct.
in just those 3, or just those requiring aspects of your text amendment, it meets those requirements. It may not meet any of the other dimensional requirements, which would require what you said, a tear down of that property and a redevelopment of that property, or they would have to go back and get zoning variances of all of these dimensional requirements in the ordinance, potentially, if they wanted to do that. And the last property would be if the board agrees to a text amendment, what we're talking about today, which is the Abington Y and the assembled properties. My understanding is there's a few other AO districts in the township, but none of them are close to a hospital in the township. I think there's one on Easton Road, maybe 2 on Easton Road, and I think there's one all the way out on Township Line in Old York Road. So
I don't know if it's necessarily correct to just look at AO properties. And the reason why I say that is this property isn't AO. This is CS, and a majority of it is R3. So to just say you're looking at AO properties that would qualify, I think you could take a property that is R3 at this point and just file for a zoning change and change it into AO H12. So I don't think it's fair just to look at AO properties, because I think am I wrong with that? Do I understand this correctly? You can reapply for rezoning of properties. So just to say you're looking at AO that are 5 acres, and you're saying there's not many of them, there's
I'll answer this question, but I think we need to avoid getting in this back and forth because really this is time for the party status, people that have identified party status to actually ask questions of the applicant, and I don't want to testify them. But your answer is, sure, I mean, the board could at some point decide to rezone any property to be any district in the township or create another district if they want to, but that's a legislative act and would have to go through a whole process. So the answer to your question is, sure, I mean, that's possible. But that's the answer to your question. But if we're only looking at properties that are currently zoned AO, including their property, if it were to get approval on the text amendment, then the ones that we've identified or have just talked about are the ones that I think are in play. Not in play, just are part of meet the requirements. So.
Okay. I think
we could talk about hypotheticals all you want to. I can't tell you what's going to happen in the future. So, but now that that's finished, I think you need to get back. If you have any more questions for Mr. Kennedy, then we need to move on to the next person that has
And if
party
not,
status.
we can have someone else come up.
Okay, so I just wanted to stress at this point with that line of questioning how important the answers to all those questions are.
Okay.
I think it's critically important to know what you're voting for and how it could be used in other settings. Thank you.
Thank you. Next person with party status for comments?
Joe Rozak, 1927 Susquehanna Road, R-O-Z-A-K. Okay, I just have one question, and it's pertinent to comments I would like to make later. And my question is, why must the hospital be within Abington Township? Give me a good answer for that, please.
That was really more for clarification purposes. There was a question rose, and I forget, quite honestly, whether it was in the Planning Commission or whether it was here, but would it apply to hospitals in surrounding townships? Now, for instance, there is a hospital down on Township Line Road. It's not in Abington, it's across the township line, and there is a small area of AO. I did look at that on the map, and I also came to the conclusion that that area could not be developed in this fashion for a number of reasons, actually. The pattern of ownership, the environmental sensitivity, and it occurred to me that the simplest way to clarify that would be to just simply say that this only applies to hospitals within Abington Township.
And then along with that, why must the hospital be within 2,000 feet?
Well, the entire intent of this is to place senior housing in locations that make sense. And not only is there typically, where a hospital is located, you typically have other support businesses and services, such as doctors, specialists, pharmacies, et cetera. And so it makes a lot of sense to try to locate senior housing in those areas where seniors could get that service within easy reach.
Okay, well, another question. What is the closest hospital to BET's 55 and older apartments, Dublin apartments?
I'm going to object. That's
No,
a completely different project and not relevant to these proceedings.
The distance is relevant. I'm sorry.
Excuse me,
The
no,
distance is relevant.
excuse me.
Isn't it relevant?
No. Counsel?
I would agree, that's not a relevant question.
Next question.
What is in another township
Well, that's the
isn't
only one I
relevant.
had.
Okay, thank you, sir, for your
I'm
comments.
sorry you disagree with me.
Thank you. Any other comments or questions from those who have party status?
Roy Gibson, 1079 Huntington Road. Gibson. My question is, it pertains to, and I was concerned about it as I read through the amendment, my understanding is you have a cap of 26 density units. Because if you add the text amendment up and the 20 density units in land development, realistically, it could balloon out to 31 or 32 density units if you take everything that was written in that text amendment.
I'm not sure I understand, but do you mean that if you applied all of the bonuses?
Yes.
You can't apply all the bonuses.
He's asking you if the cap applies.
I mean, the cap would
absolutely-
stop that from happening.
Oh, yes,
correct?
the cap absolutely applies. The reason why there are more bonuses than there is a lot of density is so that a developer can choose which bonuses they would like to utilize.
Okay, I just wanted to be clear and that the board has been looking at that. It seemed a concern for me because it seemed to be a shell game. But, thank you.
Thank you. Comments or questions from residents with party status? If there are no more, right.
Yes,
Right.
I'd like to
No,
protest
excuse me.
again that I
No,
should have
you-
party status
that
because
was
they
addressed
were
the last meeting.
negotiating with a
Ms.
property
Lehman,
within 4 blocks of my house.
Sit down, you're out of order, or you will be removed from the meeting. Thank you.
Okay, but I'm protesting the lack of
We
party
heard
status.
that the last time. Thank you. If there are no more residents with party status wishing to come forward, I'll go to the list of those who signed up. Some have already spoken. I'll start with Rebecca Fellerman.
Rebecca, Rebecca, Fellerman, F as in Frank, Ellerman. Good evening. My name is Rebecca Fellerman. I live at 1074 Wynwood Road in Abington. I'm a licensed architect in the state of Pennsylvania. At the end of the day, regardless of how you vote tonight, someone, most likely Mr. Markman, will develop the Y parcel. I hope and welcome him to take into account everything he has heard from the public over the course of these hearings. I urge him to save the Y. Hopefully, the reduced density will give him the flexibility to save the Y structure. He has heard a lot of testimony about the importance of historic preservation to this community as well as its history. The marketability of his complex will be greatly enhanced by saving this key piece of Abington history. Likewise, the cemetery. I know Mr. Markman has given testimony that he hopes to enhance and document the cemetery. And I certainly urge him to consider extending that enhancement to increasing the landscape buffers between his development and the cemetery. It is vital that the cemetery have a positive backdrop. Saving the Y will actually also help the cemetery by providing more green buffer as you come up out of the city toward the cemetery along Old York. Scale and mass must be considered given the sensitive nature of this site, not only in its setting with the historic church, the cemetery, hopefully the Y, but the neighborhoods that surround it. Again, I urge Mr. Markman to be a good neighbor to the community and to make sure that the scale of this building with the reduced density will not dwarf the neighboring properties. No one wants a 60-foot wall in their backyard. Finally, I urge him to enhance his property and the community with solid pedestrian enhancements and landscape buffers. Abington welcomes good design that is sensitive to our character, our context, our history, and our neighborhoods. Thank you.
Thank you. Next, Tish Lee.
I have no comment.
No comment? Okay. Next, it looks like Charles Frager, 1919 Hilltop. No comment. No comment? Next, it looks like Joe, I think you spoke. Right.
Those were supposed to be questions.
Right, you can still come forward and have comments.
These are comments.
This is public comment, sir.
Okay. Sure, I will. Joe Rozak, R-O-Z-A-K. President of the Board, Mr. Luker. Members of the Abington Board of Commissioners. Representatives of the Abington Township. Representatives of BET. And fellow citizens of Abington. I appreciate getting this opportunity to stand up here and give my opinions. Because this is a multifaceted issue, it is a challenge to succinctly write down and express thoughts, questions, analyses, and opinions to clearly articulate what one wants to say and stay within the guidelines of the meeting, and all in 3 minutes. After listening to speeches for how long, I don't know. Those guidelines leave our voices controlled by your agenda and diminish our chances of stating all that might be germane and in need of serious consideration. This issue revolves around process, one somewhat antiquated and stifled by the means of advertising and the language used, the text amendment itself, the reassigning of a zoning designation, and more broadly, the wise use of land. So this might take a little longer than 3 minutes. It won't be an hour. Please bear with me. First of all, This process really needs reevaluation. I'm bewildered. I find it questionable to vote for 3 items, if my assessment is correct, simultaneously. First, there is the text amendment in introducing a new category, H12, senior-only apartments, as an addition to the text of AO zoning. 1. Attached to this amendment are precise details. Many, in my opinion, are arbitrarily and expediently written. Second, there is a change of the R3 and CS designations of particular plots of land, i.e. the Y plus properties, to AO. And finally, giving BET, purchaser of said property, the right to build their high-density apartments. One could reasonably argue for well-thought-out text amendments to add an H12 designation to existing code to maintain a dynamic zoning code as our demography evolves. And then, in another vote, turn down the application to change the Y properties in question to AO, based on an appraisal that the present zoning allocations as written into the 2017 zoning codes are correct, wise, and in the best interest of the community. Along with this is an extensive list of requirements. Voting on all 3 at once muddles and confounds the issues, as was seen in the confusion I've seen over here by several commissions in trying to figure out what they're voting for. Next, the main thrust and problem of the proposed amendment hit me last week when a member of the Planning Commission asked Mr. Panichelli whether this amendment would only affect the Abington property in question. He carefully but quickly answered yes. Although some went on to argue, as we heard tonight, that there were at least 2 other locations that would fit the bill. I thought the precision of that location was a little disconcerting and strange. Why only there? What is so sacred of that spot? Surely, if Abington is in need of senior housing, no less luxury senior housing, there should also be, if it is a fair issue, other locations that could be considered. Then I realized that the part of the amendment that really played a big part in pinning the sign down to the old Y was a stipulation that the housing must be within 2,000 feet of a hospital. This is very precise. 0.379 miles, a little over a third of a mile. What? Why so? Will all those 55s and older, those who want to live independently but only not on any individually owned property in Abington, be in such dire need of medical assistance that they must be within walking distance of a hospital? They'd have to wait for an ambulance anyways. When I first read the amendment, without really thinking, because there were so many words that did not do much to paint a clear picture of what is being proposed, I thought that distance was standard, somewhat not to be questioned. I was naively and embarrassingly wrong. Now I see that the number is really arbitrary. To say the least, BET's 55 and older apartments at Dublin Terrace are 6.5 miles away from the nearest hospital. Not 2,000 feet, 17 times farther than what they are deeming necessary in Abington. That does not make sense. Is BET placing their renters' lives in that apartment complex in jeopardy because of that distance? I don't think so. It seems to me that that number was deliberately picked, along with other added requirements, so that if there really were a need for senior housing in Abington, the corner of Old York Road and Susquehanna would be the only place we could build it. Nonsense. Sorry. No other developers need apply. It belongs to BET. So, add text amendments to the AO zoning designation with new designer codes to restrict locations, then and also at the same time change R3 and CS zoning in that corner to AO because BET requested it. Use specious bonus points to allow for increased density, and then allow BET to go ahead with its plans and build a high-density apartment complex. And so, designer zoning codes are considered and possibly passed for the benefit of the developer and not necessarily for the benefit of the community and apartment dwellers. This is clearly spot zoning and should not be allowed. This should have been stopped a year ago. I believe that Mr. Markman's time as a representative for BET, that his time on the other side of this room, as your colleagues, may have been giving you the opportunity to encourage him to keep on changing so he could fit what is required. I may be wrong in that assessment and probably out of line, but I'm starting to think that way. I'm sure I'm not alone. As open land becomes more and more scarce, the issue of overdevelopment will become increasingly serious. The dire need to oversee development decisions by commissioners and town supervisors was discussed at a symposium at St. Thomas back in November. I attended that meeting to compare notes. It was an enlightening meeting. Developers are rewriting zoning codes for their benefit in many local townships, not only in Abington. In no way am I saying this is a conspiracy, but to a developer, land not making money is fallow land and available for exploiting. Making money should not be a deciding factor. The value of land lies also within its ecology and social importance as a community resource, historical value, and an aesthetic feature. We, as invested citizens, must give oversight to this process to help commissioners apply appropriate constraints and wisdom. Please bear with me.
Are you almost done, sir?
I'm halfway there.
Halfway?
More than halfway.
No, excuse me, excuse me.
Please.
You've already spoken for 6 minutes. Now,
I
that's.
know that, I know
But
that.
only
They've
halfway
spoken-
there?
I haven't, I
Why
want
don't
to
you
make
just
sure all
read
my
us, why
points.
don't you just read us your closing sentence? Thank you, sir.
I've got two more paragraphs before that closing sentence, and these are the most
You
important
got to
parts.
move it. You have to move it, sir.
I appreciate your time. We've sat here and listened to this for over a year.
Start reading, sir. Thank you.
At the last meeting, I will address two of BET's own selling points: increased tax revenue for the township and an invidious comparison of 55 and over apartments to other possible uses of that land. At that last meeting on December 18th, a boost of about $700,000, could be lower now with the lower density, I'm not sure, in increased tax revenues was presented to sound like a real positive that would seemingly lower the tax burden of others in Abington. But is that amount significant? To an individual, it is. However, that is only about 1% of the township's budget, or at least the 2019 budget I saw posted on the township website, a budget that projected a surplus. That's a penny on the dollar. Any food server at a restaurant would be deeply insulted if you thought it was significant. The significance of the tax revenues would diminish even further, be diminished even further if that tax revenue number were appropriately compared to the revenues that we brought in by properties built according to the zoning codes that are now in place. So why unnecessarily sacrifice the land with that offer? If one were to make an, well, I'll skip that part over there.
Thank you.
Okay, fine.
Wrap it up. You have 1 more minute, sir.
Oh, boy. There are several fears. Well, there are several fears that go along with BET not taking that property. One is, what's going to take its place? Well, in my opinion, the fear of inappropriate places being put there would be applicable if, only if the Board of Commissioners did not stick to the zoning ordinance that is now in place to protect the community from inappropriate land use, which I could not finish with. If they were not held to following their own rules and regulations, supported by you guys, supported by diligent input and oversight from those in the community, are responsible for the direction we take. Then again, I am sorry to say that fear is probably true if you do not stick to where we were before with our zoning.
Thank you, sir.
I have a lot more. Thank you for the time, and if you want to hear more, I can leave this with you.
No, that's quite all right. You had 11 minutes, so that's ample time. Thank you very much.
I appreciate it.
Thank you. Next, Mr. Roy Gibson. You spoke as a, right.
You can have public comment also.
If your wife wants to speak, Anna? No comment? Okay. Michelle Tinsman?
Michelle, first name, last name's Tinsman. T is in Thomas, I-N, S is in Sam, M-A-N. Sorry. Is that better? I'm too short. I'll be much briefer. I thank you all for having these meetings, and I would urge all of you to stick to the zoning that you have passed in the past year. I don't see the need to alter the zoning. You just spent a lot of time coming to revisit the zoning in this township and to come in and allow a developer to go in and make changes so quickly. I just don't really think it's necessary. I applaud BET for coming down with their density, but I don't think it is down far enough. You will fundamentally change the neighborhood by having this dense of property. Development in this area. It is already a very congested area in the township. I don't know how many of you spend a lot of time walking around that neighborhood, but I do. There's a lot of cars in there, and it will be very, very adversely impactful to the immediate neighborhood. So I would urge all of you to please not to support this. Thank you.
Thank you, Michelle. Christine, looks like Dawkins, maybe? Thank you. My apologies.
Christine Dardaris, Dardaris.
Wow.
1065 Huntington Road, Abington. Well, this property is the heart of Abington, as you all know. And the YMCA was used as a way for the community to come together. I guess just one more comment would be if there's any way, like prior residents have mentioned, to incorporate the facade at least or part of the Y building into the new development and perhaps use it as a community center and maybe have a portion of the property be used for community use. That would be a benefit. Also, this is senior housing, but for seniors in a certain tax bracket, what would happen if the market takes a downturn and you can't sell or rent all your units? Will they be coming to the board again to ask for more rezoning to allow maybe lower income people to come in or just rent to families and then put a tax burden again on the school system? Is there just another idea to keep in mind? Also, should maybe some of the units in the property be designated for lower income senior citizens? Not many senior citizens could afford the rent they are asking. Just another idea to keep in mind. Thank you.
Thank you. The last name on the list is Sophia. It looks like Chisholm. Sophia, 626 Wanamaker Road. Okay, that takes care of the list of sign-ins. Are there any other comments from residents?
Okay, it's Herb McMahon, McMahon, 1046 Huntington Road. I was asking the questions earlier as party status, but I just want to expound on what I think of this project in general. I think the process has been flawed because I think the testimony given to those other commissions, as I stated before, has been not accurate and maybe half-truths or flat-out lies. I mean, to say that under oath before that that Mr. Kennedy didn't feel as though the sunrise would qualify. I mean, I think that you all have to look at that, and I don't know how you're going to do it at this hour before you vote, but I think that it should be considered. And I think that the other thing, you've had two planning commissions, one on the county level, one on the local township level, that have been misled. And you've also kind of like alienated your residents by not giving them notice, by not acknowledging certain properties that may be used for H-12. I also wanted to go into the finances because that's another huge thing that Mr. Markman has been showing on his slides. Back when it was 36 units, you were looking at $600,000 in taxes, and that was roughly 1% of the budget. And now that it's been reduced, you're probably looking at $400,000, which is just a little over 0.6%. So it's not even barely, 0.5% of the budget. And I think that's important to note because I think the more you tout the money, people may be misled again because it's really not a lot of money. If the property was developed R3, you could probably fit 20 homes on that, and you would probably see anywhere from $200,000 to $300,000 in taxes from that. So I think that the financial end of things aren't quite as great as what they're being portrayed. I also wanted to reiterate that I believe it's spot zoning because it's inconsistent with what's surrounding that property. I think R3 was what was consistent, and I think the way the text amendment is written is meant to exclude every other property that could possibly be thought of, either by saying Abington Township, Abington Hospital, whatever other pieces are thrown in just to exclude everybody else. It should probably read only by use by BET. And then finally, I wanted to make sure that people understood how muddy this process has been. As Joe, I believe it was Joe, said that there's been 3 things that have been considered. And I think that the Abington Township Planning Commission was confused even on what they were voting for. At one point, there was a 4-4 vote. Then the next meeting, there was a 5-1 vote, completely opposed to it. And I think the problem was that people were opposed to the text amendment. Every single commissioner, except for one, had stated that they were opposed to the text amendment. Only one said that they were for the text amendment, and most said that they liked the project. So you have the project as one piece of this, you have the text amendment as another, and each one of the Planning Commission commissioners had stated that they did not like the text amendment per se. The last thing I wanted to get into is the historical cemetery. It's one of the oldest cemeteries in America. The first person that was buried there was buried in 1728. She was a 33-year-old female who was one of the 70 founding members of Abington Presbyterian Church. And just to give you an idea where we were in history in 1728, Ben Franklin was only 22 years old. He had not even set foot in Philadelphia by that point. It would be another 8 years before he came to Philadelphia. The Liberty Bell was created 25 years later in 1753. And you can walk through that cemetery and see all these stones. And I just think that it is a historical site that needs to be protected. One last thing, can I ask the commissioners questions? Can I ask you all a question?
Not really, but
The question I had would be, with the Meadowbrook Apartments, would a judge allow the use of H12 just over a road or a driveway? Or would a judge just say, it seems like a reasonable variance?
is that a question that you want to address, Counselor?
I don't know what a judge would do, and this is sort of hypothetical.
Right. Okay. All right, sir, is that it?
I think that's it. I'm going
Thank you.
to, in my closing statement here, just ask you all for a no vote. I think for all those good reasons, I would ask you to vote no.
Thank you,
And I'm
sir.
sure that you've heard from a lot of people, there's been hundreds of people that have either participated in petitions or allowing lawn signs on their property, and people have phoned you and written you, and I beg that you take that into consideration. Thank you.
Thank you. Are there any other comments from residents? Sir. And then the young lady, why don't you come first, ma'am? Go ahead. Name and
Teresa
address.
Johnson, I live on 1130 Kingsley Road.
Did you get that, ma'am? Okay.
I would just like, Commissioners, I'd like to express my support of this project. I have been attending these meetings, and I know sometimes it can be very difficult, especially for the people that live close by. I've been very impressed with the developer, BET Investments, and the thoughtfulness of the process, listening to comments, going back, making revisions, and trying to really understand what the public is concerned about and meeting those concerns. And I think the density issue from the last meeting I attended was a huge concern, and I think they have addressed that. And also the traffic. I mean, driving up and down Susquehanna, taking a left or right there at Old York Road has been sometimes you wait a long time to make that turn. I think there have been traffic studies that were shown to us that prove that we're gonna have a lot less traffic coming in and out of that location. I also was very impressed with the concern about the historical significance of this site, the desire to create an education program around the cemetery so that we learn, especially our students, that learn about this and take the opportunity to learn by who is buried there and the significance of that site, that younger people in our township will learn more about the history of our township, which is so rich. And I personally believe that there is a need in our township, and I don't think that it's necessary. There are a lot of people that live in our township that do have means and that are leaving our township to find a place to live once they enter this demographic of over 55. So I do believe that this is an option that a lot of people really don't have right now, and I would ask you to consider that as a thoughtful reflection, that this demographic is very underserved in our township. And I guess in closing, I would like to say that the thoughtfulness of this developer to really understand and make changes and be willing to make those changes and to do what the public is asking has been very impressive to me. And I think that they've shown good faith. They also have a very good reputation. I was on their website looking at some of their other projects. This is not some fly-by-night developer that's just all about making money and lining their pockets. They're committed to our township, to this area, and they're well invested in it. And I think we should take heed to that and really understand that they have committed a lot of resources just to go this far with this project. They're very committed to our community, and they've spent a lot of money in this community and made it a better place. So, Commissioners, I would ask, I know there's been a lot of negative comments about this project, and I would just ask that you also look at the other side and the need that we have to have such a fine project. I personally believe that this will be a great point of pride for our community if it is built. Thank you.
Thank you. Thank you. Sir? It was a gentleman who was coming up behind her. All right, Doug, thank you.
Hi, my name is Doug Callantine, C-A-L-L-A-N-T-I-N-E, and I live at 2032 Horace Avenue in Ward 11. And I'm also a member of the Township Economic Development Committee. And I also want to speak in support of this project, and for a couple reasons. One, I have to commend everyone on this public hearing process. It's been going on now for the better part of a year, and I've been impressed with the amount of citizen feedback, township official feedback, as well as feedback from the developer himself, themselves, I should say, and listening to what the comments, concerns, issues that have been raised, the changes that have been made in the project in terms of its size, its density, its height, its setbacks from the road have been impressive. I think it's at a size now that probably makes sense and is viable not only for the township, but also viable from an investment standpoint from the developer's perspective. The off-site improvements that they're proposing in terms of helping maintain the cemetery, or at least improve the cemetery sidewalk, as well as the fencing around it, and the educational program is a very strong effort on behalf of the development partner, the developer, to see the need for enhancement beyond just the site itself. And I think there's also been a commitment to provide a significant amount of funds for the improvement of the Old York and Susquehanna intersection. It's probably not all that's going to be required, and hopefully the township will see other ways in which that intersection can be further improved. But again, another attractive addition to this public hearing process where there's been a fair amount of give and take. I've also had the opportunity to visit two of the recently, or actually one BET project that's under construction in media, and another one that was recently completed. And if anybody's had the chance to see those projects, I think you would all admit that this is going to be a real enhancement for our community. The physical plant of the buildings themselves is very attractive. The public space within the building is very attractive for the residents, and I don't think any of us will be ashamed to see this building at that location. And I'd also remind people that the YMCA is selling this site, and they're counting heavily on the proceeds from the sale of this site to fund the project that they're building in Willow Grove. So I think it kind of reminds me of the old saw, the devil you know, excuse me, the BET, but the devil you know may be better than the angel you're hoping for. So keep that in mind. So now from an EDC perspective, and sitting on that committee, we heard a presentation from BET on two different occasions last fall, talking about the economic benefit to the township. Obviously, with the reduced size, that economic benefit is probably somewhat less than what it was before, but nonetheless significant. There's no tax revenue being generated from that site today. Whether it's $400,000, $500,000, or $600,000, that's a net improvement to both the school district and the township. It's not going to save the township from financial ruin, but it's one of the important building blocks that this township needs from an economic development standpoint to be successful. So I would not discount at all whatever the level of the tax revenue is that's going to be generated from this site. Finally, I'd like to say, and if you haven't realized, I'm in the target demographic market for these apartment units. And I have to say, in many of the conversations I have with my peers, it's very common to say, hey, where are you looking to live in the future? And for most people, if they want to have apartment-type living or some sort of a condominium-type living, there aren't many options here in Abington. So this presents an opportunity for us to retain Abington residents who want to stay in Abington. And so I encourage you from that perspective as well. So finally, I'd just like to say I really believe this is an important project for the township, and I hope you all see that as well and vote in favor of this project. Thank you.
Thank you, sir. Any other comments from residents? Yes, sir.
John Abreu is my name, Abreu, 932 Cricket Avenue. Board of Commissioners, I just wanted to add my name as one of the additional people who are completely against this project. I've been listening to what's been going on for a year now, and I just don't understand how a Board of Commissioners have enacted laws, zoning laws, preventing this type of construction, and for some unknown reason to me, this continues to be, it just continues going on. I just don't understand it. I've seen hundreds and hundreds of individuals coming up to you, begging not to do this, not to allow this to continue. I felt compelled to add my name to the list after seeing what's been going on and not understanding why this continues. We voted you into office, understanding that you're going to be looking at our best interest and looking out for the community. And I personally don't feel that some of you are doing that, and I don't understand why that is the case when you clearly see the citizens of this township begging you not to build this or construct this building. So I am here to add my name and to beg you to please vote no to the continuance of this project. Thank you.
Thank you, sir. Any other comments from residents?
Hi, Tina Van Buren, Vanburen, 1601 Meadowbrook Road in Meadowbrook. I just want to let you know that I am in support of BET putting something at the YMCA site for a number of reasons, one of which they've already been expressed, but as a longtime resident of Abington, I'm not quite at that age yet, but to be able to have options, to be able to stay in our township where we've raised our children would be a great option to have if you wanted to do other things. I do think the tax revenue that it could bring into the township as well is an increase. I do think all of the ideas that they have had to make that site better is a positive as well for that area. So I am in support of BET moving forward, and I hope you see it as well.
Thank you.
Thank you.
Any other comments from residents?
Sorry, I was hiding behind the monitor there. Brian Wasson, W-A-S-S-O-N, 914 Wesley Avenue. I'm in Ward 3. I appreciate the time and the effort that BET, commissioners, and everybody else has put into this. I must say I have not been involved very much with township politics before now, so this has been exciting to see, and I commend you guys for all allowing this. I'm a third-generation Abington resident. I grew up here. My parents are here. My extended family is here. My grandparents died here at Abington Hospital. Both of my extended family still lives here. So I say that as somebody that probably lives in something that was developed at one point when, in 1950-something, people sat here and had the same discussion. Probably all our houses are the same. So I'm not anti-development. I'm pro-responsible development, I would say. I'm not anti-BET. I don't want that message to come across because from what I've seen, they're a good, responsible developer. I do believe that this is I won't overstate it by saying it's a once-in-a-generation opportunity to get something right, but this is something that's going to have impact on all our families if they choose to stay here for generations in the future. I don't have property directly impacted by this, but I, like all of you, drive Susquehanna, I drive Old York Road, I drive Valley Road. Anybody who drives that knows it's already gridlock often. We just heard 240-plus apartments to Beaderwood area. Adding Rydell Waters is going to increase traffic density on all those roads. I think this needs to be taken into consideration as part of the context of this, not just as one development, even though I know we're talking about this right now. I'm trained as a journalist. I work in public relations, so I know that words matter. This is continually being presented as a senior living facility. It is that, I grant that, but it is a high-end luxury large apartment building too. Just calling it a senior living facility, I think sometimes glosses over the fact of what it really is. Whether or not it's needed, that's not for me to discuss. I've also heard in previous meetings, BET refer to this, and I quote, as a life care facility. If you look up the definition of life care facility, it's a life facility for elderly persons, from independent living to culminating in a full health and continuing care nursing facility. They used that, I believe, in the previous commissioners meeting. Again, my journalism note-taking. That at the same meeting, Mr. Markman said, and I quote, "We are an independent living and we don't provide any services." So that kind of is diametrically opposed to calling this a life care facility. Well, I think BET's amended lower density proposal, which they've come back with, is a step in the right direction. I commend them for that and going back to the table multiple times. I think it's still well above the current permitted use and density for that, so I'd still like to see that worked out a bit. The comment that a previous presenter made about the devil you know, and I think that's an unfortunate term, as he said as well, even better than the angel you wish for. There's this specter of, if we don't do this, something horrible is going to go in there, maybe another Wawa, something of that nature. That's kind of a disingenuous argument, I think, because we don't know what might go in there. We don't know what's possible, as somebody, I think, said in a previous commissioners meeting that commented. So all those things taken together, I don't think it's a slam dunk to say don't develop there, personally. I just think it needs to be more responsible development, lower density, taking into context with everything else that's going on in this very small, I think somebody commented, a half mile, maybe even a mile square area where a lot of development is already happening or in process happening. So I appreciate your time and efforts. Thank you.
Thank you, sir.
Laura Lehman, 1431 Bryant Lane. So where to start even? First of all, I don't think there is a need for this ordinance at all. Mark Pennicow wrote in one of his reviews that he felt that this fit in the E10 use just fine that actually
Ms.
is
Lehman,
already
could we
there.
dispense from names? Just make your comments. Thank you.
No, I think the name is important. It was Mark Penical's review.
It's not important.
Why, that is important.
Keep moving, please.
It's
Thank you.
important. He's the zoning officer, okay? And frankly, if people do something, they should be responsible for what they do. If I say something improper up here about what he did or didn't do, that's on me, okay? But you can't cut off the people's right to understand who's serving them and what they're doing. So Mark Penical did write a review, and in that review, he said that this particular thing works under E10. So my question is, why was that not considered? Why was that not even brought up anywhere along the line? I don't even understand. E10 is allowed 24 units. I read it over. It's a little ambiguous because it's under the life care category where it says people, that need life care. But it does then have a category for apartment building with 24 units, and Mr. Markman would not have to begin to change our whole zoning. He could apply to have a map amendment. And I would recommend that that's something that you consider. And I don't think that we should be here at any final hearing when anybody in this deciding body doesn't understand that. And that's because nearly every single meeting, these things were directed in Mr. Markman's, to Mr. Markman's conditional use hearing. We needed to direct this to what other properties this was and what the zoning is. The zoning on this property includes E10, both in the CS district and in the R3 district. So that actually is an extremely important point and should be considered before your vote. And you also have the option of putting off your vote until you study that and understand it. What was said earlier about the many deceits in this process, this meeting is completely tainted. I believe Mr. Kennedy has had untruth after untruth after untruth in the things that he wrote and the things that he said. And I think that it's important to address those things. So among those things, for instance, are him saying, at this point, we're at the end of a year's worth of work, and Sunrise at Abington is something that he doesn't know that it fits this particular thing. There is no reason it doesn't fit. And he said, well, it doesn't fit because they would have to tear down the buildings. That's not a reason. In fact, it does fit. And that's what happened when they took out Meadowbrook Apartments. I went to the township and began looking at parcels and found out a whole lot of things. So first of all, Valley Glen, until the hearing, Valley Glen was not brought up, even though I asked it at the very first Planning Commission meeting about the properties over by the Elkins Park Hospital. When it was finally brought up at the hearing, the way of resolving it was to spot zone it out. Oh, we don't want that property? Okay, we're going to put in only Abington hospitals. That's called spot zoning. That property actually did fit this zoning. And he has been doing that with every single, and now Mr. Penical, again, in his review, mentioned spot zoning and said that the 2,000 feet and the 450 feet from a bus stop and all of that was indeed spot zoning. Do you understand that? So what happens when we have somebody that comes in and is doing spot zoning? Who takes care of that? That's supposed to be, I guess, Mr. Penical told you, and now you're supposed to bring it up at the meeting and the planning meeting. But it wasn't brought up. It was not brought up at all. And that's what's wrong. This whole process has been skewed. I also want to say that we have a different ordinance that we're hearing tonight. This ordinance that's up there with all the blue lines, you can see this is a different ordinance than we had before. And that Abington thing that you saw on the first page, that was just added. That took out a property that had the right to be in. Okay? And so you literally are having the first part of the hearing on one ordinance and the second part of the hearing on another ordinance. And that is part of the corrupt process that this has been.
Are you close to wrapping up your comments, ma'am?
Well, no, because there's some things that have been said tonight that are very important for people to understand. So, for instance, Mr. Kennedy in his report said that this agrees with the county.
I'm going to give you 2 more minutes, Ms. Lehman. Go ahead.
The county agrees with all this. Well, let me tell you, the county is not approving this zoning. In fact, the county representative sat with the entire group that was making this ordinance, with Commissioner Klein and his whole group. And the county had their say how this would be zoned, and they decided it would be zoned R3 and CS. He's saying that it could be zoned RO, AO. They did not choose to do that. Colton Hall could be repurposed, and it's a shame that anybody would award somebody for teaching children about history while they're tearing down the most important historical piece that we have left. Colton Hall, and I sent you all a thesis on Colton Hall. That's how important it is. It's been the subject of much discussion. The spot zoning, I want to have that addressed. I want to understand we are spot zoning here in every way. Meadowbrook Apartments has 2 entrances to a primary road that takes them to a hospital 1 block away. There is no way that a judge is going to say, no, you don't comply with this, because the purpose of having the primary roads and all of that is to get you to the hospital.
Okay, are you
There's
just
no
about
other
done, Ms.
reason.
Lehman?
So let me just say, you know, and I also want to say that we have, in reference to the people that are doing this, I sent you all an Enquirer article. $329 million is what Toll Brothers still owed to the people in that Enquirer article. Yet he had the millions to come and buy this, but not pay those people back. We do have to care about who it is that we're working with. And that is important, that they did not do those people right that they built by. And that's one of the partners in this firm, that he was part of that firm at the time. Okay? Perjury was committed in the first part of this.
Okay, Ms.
And that
Lehman, I
taints
think you're
this
going
hearing.
down the slippery slope here. I don't want to get into a legal
All right, fine.
battle here with
all
you.
right,
Could
and
you please wrap it up? Thank
Yes,
you.
I will. Yes, I will. I want to tell you that allowing developers to come in and have unconsidered, self-serving articles in our zoning is making a mess of our zoning. Those bonuses are not necessary. There's an E10 use where he could have 24 units. Please turn this down or continue it until that's completely considered and actually looked at, and a response is given to the residents of this community why you would allow that.
Okay, thank you. Any other comments from residents?
My name's Stephen Lee, L-E-E, 1073 Huntington Road. I am here to speak against the ordinance. I'm not really against the project, but the way the ordinance is written, right at the beginning, it says the intent is to provide a wider range of housing opportunities for senior citizens. 1 year ago, BET told us that they could fill 216 units if we would allow them to build that. We decided that that was too big, but the rest of the ordinance is stating that nowhere else in the township could we fit in the approximately 70-some units that they've decreased theirs by. So if the ordinance is actually to provide for senior citizens, then it shouldn't be written in a way that only one parcel in the township would fit the bill. And one other thing in the ordinance that I questioned the applicant at the December 18th meeting about the steep slopes. When I asked the question, they told me that it was not in the ordinance. And one of the commissioners looked it up, and we found out that it was in the ordinance. And I asked them what was the purpose of that section of the ordinance, and they told me they didn't know, but it's still in there. So if the applicant doesn't know why sections of the ordinance aren't in there, I don't think that any of the commissioners should vote for it. Thank you.
Thank you. Any other comments from residents? Comments from residents, and if there are none, that'll conclude our comment section. At this time, Counselor, I'd like to know whether we need, I'm sorry.
Comments from the board.
Oh, okay. Before we get to the comments from the board, are we going to have two motions, one for the zoning ordinance amendment and one for the map amendment?
It's not necessary.
Okay.
You can do it all in one.
Okay. Thank you. Okay, thank you. Any comments from commissioners? Okay. Vice President Klein.
I just wanted to follow up on a couple things and ask the applicant. Have you considered the concerns that were brought up about spot zoning, and can you respond to those?
Yes. We don't agree with the residents' interpretation of spot zoning. Spot zoning has been interpreted by the appellate courts in the Commonwealth of Pennsylvania. We have submitted a memorandum to your solicitor as to spot zoning, and our interpretation by applying the facts of these applications would not constitute spot zoning as it's been set forth in the laws of the Commonwealth.
And that document that you submitted, would that be a public document?
It's a memorandum that was submitted to me earlier today. It's no reason why it wouldn't be. There's no privilege on this document, and will be subject to a right to know request.
And Mr. Clark, have you had a chance to, since you received it only today, have you had a chance to review that?
I have.
And are you in agreement, or do you have any concerns about spot zoning that's been brought up today?
I agree with their analysis, and I do not have concerns that this is spot zoning. I think, as I may have mentioned earlier, if we believed it was spot zoning, we would have brought that to the board's attention long before tonight. I don't believe that on the definition of spot zoning that have been handed down by the courts in the Commonwealth of Pennsylvania that this qualifies as spot zoning.
And my last question following up on some of the comments that were made by residents about the steep slope. I mean, does anybody have an understanding of the steep slope provisions that are in the ordinance and would like to explain that?
Yeah, I believe Mr. Markman's here. There was a question, Mr. Markman, concerning a provision. Oh, Mr. Clellan, I'm sorry. Took my glasses off. Pete Clellan.
Name it.
Peter Cleland, C-L-E-L-L-A-N-D, with BET Investments.
Mr. Clellan, you're a licensed professional engineer?
I am.
Okay. And you're familiar with the provision that was referenced concerning man-made steep slopes? In the
Yes,
ordinance?
correct.
Could you please explain the?
We did go back and look at that, and my recollection, and we frankly what we don't know is whether that would be applied to a particular part of the property, but there is a section of the property along Susquehanna Road that we frankly cannot determine whether it does or does not qualify under the steep slopes ordinance. It is very clearly man-made from the construction of Susquehanna Road near the backfield of the YMCA. It's a very limited area. And that provision was put in the ordinance to allow the construction along Susquehanna Road.
And was there a qualifier that was put in there after consultation
Yes,
with township staff?
yes, that the project would have to applicably demonstrate that the disturbance does not create an increased erosion risk on the slopes, which is the point of the steep slope ordinance.
And that would be something that would be reviewed by the township engineer as part of the land development approval process?
I think it would first be reviewed by the zoning officer in conjunction with the township engineer to determine whether that section of the property is a steep slope or not. And then if it was determined that it was, this provision would apply.
And then my last question would be, there were some comments made by one of the speakers about the process, or some of the speakers about the process, and perjury, I think, was thrown out there. and I asked this question to the solicitor, I'm assuming the solicitor's office is, or I know for a fact the solicitor's office has been in touch with the process, the entire process for this project. Is that correct?
That's correct.
And are there any concerns that you have related to any of those accusations that were made that would cause concern about the process?
Well, I certainly don't have any concerns that anyone on behalf of BET committed perjury during these hearings. First of all, it is legally impossible for anyone from BET to commit perjury during a land development application or a zoning amendment because perjury can only be committed in a judicial proceeding, and this is not a judicial proceeding. So I have no concerns that any perjury was committed. And I also, in reviewing the information that has been provided, being wrong about something or misstating something or saying something that people do not agree with doesn't make it perjury or doesn't make it unsworn falsifications. So I have no concerns about that at all. And again, if I did, I would have brought that to the board's attention long before tonight, and we would have addressed the issue.
That's all I have. Thank you.
Thank you. Thank you, Councilor. Excuse me, you're out of order, please. Thank you. Sit down. Sit down. This is not the time to ask your commissioner anything. Thank you. I said you're out of order. One more time, you're out of here. Thank you. Okay, at this time, then, I'll entertain a motion that council says we can do both the zoning ordinance amendment and the map amendment in one motion.
I'll make the motion, Mr. President.
Okay.
Second.
It's been moved and seconded. May I have a roll call, please?
Commissioners Meyer? Yes. Commissioner Brodsky?
Yes.
Commissioner Rothman?
Yes.
Commissioner Sanchez?
Yes.
Commissioner Thompson?
Yes.
Commissioner Schreiber? Yes. Commissioner Carswell?
Yes.
Commissioner Spiegelman?
Yes.
Commissioner Beatty?
Yes.
Commissioner Gillespie?
As an Abington resident whose grandparents came here in 1910, yes.
Commissioner Zappone?
No.
Commissioner Bowman?
Yes.
Commissioner Klein?
Yes.
Commissioner Weaver?
Yes.
13-1, motion carries.
Okay. The motion passes. And at this time, I'll first entertain a motion to close the hearing.
So moved.
And hearing that, I'll entertain a motion to adjourn the meeting.
So moved.
Thank you.
Thank you.
Thank you.
Sixers versus Golden State tonight, if I can stay up for it.
That's not fair. 8:30.